Protecting intellectual property is important, as doing so allows the holder of a trademark or a patent, like an SME, to get a return on their investment and reap the rewards of their innovation. The Intellectual Property Rights Enforcement Directive, adopted by the European Union in 2004, seeks to protect both these property rights and also cultural content protected by copyright.
We think that the current directive has been very successful. It's one of the very best that has come out of the Commission for long, and it has been implemented very well in many of the contract or the member states. Now, that's not to say that you couldn't do it even better, but I think it has worked very well, and I actually think that this is more important for the SMEs than for the big guys, simply because we get a more well-functioning and structured system in Europe with more legal clarity than we had in the past.
Clairement, aujourd'hui, l'innovation, ça vient des petites entreprises. C'est au sein des petites entreprises, des PME, qu'on va trouver l'innovation, et moins au sein des grands groupes. Donc clairement, quand vous avez une innovation qui arrive, c'est derrière des entreprises qui vont déposer des brevets, qui vont déposer des marques. Mais c'est vrai que l'accès à ces outils de protection coûte très cher. Si vous voulez déposer un brevet, vous allez passer par des intermédiaires qui eux-mêmes vont facturer énormément de frais. Et clairement, on a une vraie difficulté aujourd'hui pour permettre déjà, aux petites entreprises de protéger leur patrimoine et toute leur création. Et deux, surtout ce qu'on a en plus, c'est une vraie difficulté pour ces petites entreprises d'avoir des outils qui vont permettre finalement, en cas de litige, d'aller se défendre.
So I can tell you a story about an album I produced by an artist called Toya, which I co-wrote all the songs on. A friend of mine sent me a link. This was released 2 or 3 years ago. Sent me a link, and it's available for £2.50 from a site I've never heard of. I gave them no rights because I own all the recording. So there is a direct example of why this deeply affects my living.
In April this year, Member States and over 100 organisations gathered at a conference organised by the European Commission and the Danish Presidency to discuss whether the IPR Enforcement Directive is still fully fit for purpose.
Aujourd'hui, cette directive, elle est bonne. Il n'y a pas besoin de forcément modifier le texte de la directive. On peut dire, on peut avoir quelques aménagements, venir préciser quelques notions, notamment la notion d'intermédiaire, mais clairement, le cadre est parfait. Ce qu'il faut faire maintenant, c'est tout simplement s'être autour d'une table et trouver comment on fait pour l'adapter, plutôt l'appliquer le mieux possible, pays par pays, mais également secteur par secteur. Aujourd'hui, quand on parle d'Internet, on est toujours à dire qu'il faut créer de nouvelles lois, il faut créer de nouvelles règles. Ce n'est pas la bonne solution. Internet est toujours en train d'évoluer. De nouveaux produits arrivent, de nouveaux services arrivent. Donc rien ne sert de créer des nouvelles règles. Plutôt, il faut trouver une manière intelligente, finalement, d'élaborer une sorte d'interprétation permanente de ces règles-là. Et en fait, une session comme celle-ci, c'est un parfait exemple d'outils qu'on peut mettre en œuvre au plan européen pour justement trouver l'adéquation entre le cadre existant et les nouvelles pratiques aujourd'hui.
It's actually one of the best directives that's come out of Brussels that I've seen in the field of intellectual property. It wasn't too ambitious, but it was sufficiently ambitious. It has made a significant difference in a number of European countries. What it did, basically, was to try and look for the best things that were being done in different countries and put them all together and say everybody should have these best things. And that's roughly speaking what it says. It's not very detailed in some of the best things, which is maybe why the next step could be to provide a bit more detail.
I think the ultimate issue that needs to be addressed is ensuring that European citizens accept the current legal framework as being legitimate and then look at the enforcement issues. The European Commission has said that infringements in the online environment are ubiquitous. And that level of infringement means that IPR is just not considered credible by a huge portion of the population. And it's that credibility gap that needs to be solved first before issues of enforcement are addressed any further.
Well, PRS for Music are very, very keen that we should educate as well as legislate, because there's a lot that can be done while the directive's making its mind up, so people understand that there are legal options too.
There were, of course, subjects like the cost of litigation, which this directive is not going to cure. The poor have always been with us, and that's the fact. And it costs money to go to court, and IP litigation is likely to be expensive, particularly if it's a disputed IP right.
I think the most important thing in civil IPR enforcement is to not just think about enforcement. There's a whole complex web of EU legislation on intellectual property, and currently it's simply not working very well. And if you focus on enforcing legislation that's not working very well, we'll never get to the core of the problem, which is legislation that currently isn't really very fit for purpose.
The subject matter is whether this directive, which people broadly agreed has been a very successful directive, now needs a bit more fine-tuning. And I was agreeably surprised by how many people came up with constructive ideas, which I think the Commission will want to take forward. Quite a lot are quite technical, and even though they're technical, they're quite important.